And let's wait for 5 minutes. Not all members are present.
Good morning, Chair.
Morning. How are you, Honorable Swart?
Good morning to you, Chair. Very well, thanks. I'm just pleased that our WIPS meeting has been postponed, so thank you. I'll be joining you this morning. Thank you.
Okay. So you'll be with us for the whole day?
As long as I can.
No, that's fine. That's good. Thank you very much. So the programming committee, will it sit tomorrow?
It will be sitting tomorrow as well. It will be sitting, yeah, but not the WIPS forum as presently advised. We are sitting tomorrow, but I will let you know about that as well.
Okay, that's good. Now it's 9:30. Good morning to everybody on the virtual platform and those who are watching us from home. We are all welcome. We are continuing with the report of the department on the cannabis bill. We started yesterday to receive these responses from the department. Mr. Robert will be leading us on the responses from the department. Mr. Robert, over to you. Or let's say before we proceed, are there any apologies? Committee Secretary?
Chair, from my side, it is still Ms. Ramulubi.
Okay. Okay. So we only have one apology. Thank you very much. Let's proceed.
Thank you, Mr. Chairperson. We're currently still busy with clause 5 of the bill, which deals with smoking and consumption offences. I'm halfway through the discussion of the comment responses thereon. I'm going to resume from page 58, namely paragraph 6.12. And there is a comment to the effect that, firstly, the bill doesn't consider the current reality in South Africa regarding households vis-a-vis a private place where cannabis can be used. And it's pointed out that in most neighborhoods, there's very limited space. And if you use cannabis in your backyard, the neighbor will probably smell your smoke. It will at least go to his house. And it's proposed that we need to align the bill with the standards applied to tobacco. And I already previously indicated yesterday that the bill has got a more stringent requirement than the tobacco legislation. However, if you deal with the regulations that may be made, we will obviously look at the Tobacco Control Act regulations and align our regulations therewith. In paragraph 6.13, there is a comment to the effect that the bill does not have the same strict regulatory control measures as that applies to tobacco and alcohol in South Africa. And they refer, among others, to amendments to the Liquor Act, which actually raised the age, and I did indicate previously that bill was never passed. And also the tobacco control legislation to deal with second-hand smoke, where there are certain smoke-free spaces. And also refer to the current tobacco control regulations where there must be marking and packaging and the advertisement of tobacco is prohibited. Insofar as it deals with the stringent controls, firstly, I already indicated yesterday that a bill which increased the drinking age to 21 years, I don't think it was ever passed. Dealing with tobacco control legislation regarding second-hand smoke, already indicated yesterday, the bill has got more extensive control regulations in place to limit the use of cannabis to a private place. They already deal with so-called smoke-free spaces. And obviously that cannot be accommodated in terms of the bill due to the fact that it in general prohibits the use of cannabis in a private place. And the bill cannot follow the same harm reduction measures as that applied to, amongst others, tobacco, due to the fact that there's no commercialization. So you cannot sell it and have certain warning labels on packages. If you sell it, you commit an offense. Going further to the other...
But Mr. Roberts, what happens when you now have, let's say you have the strategy from the Department of Trade and Industry in place and there is massive commercialization? What would happen then?
Mr. Chairperson, if there is commercialization of cannabis, I believe that the legislation that regulates it for commercial purposes must further regulate this aspect. If there's no such legislation, the bill will be applicable. If there's other legislation, I hope that they do amend some of the provisions of the proposed bill to bring it in line with commercialization. Obviously, I must point out, this may be regarded firstly as a kind of interim measure pending finalization of other legislation.
Okay. Okay.
Thank you.
Mr. Roberts, you can proceed.
Sorry, Mr. Chairperson, I believe I got kicked off. In paragraph 6.14, it's again a referral to the Rastafarians that may have, or rather have, a kind of right to consume and use cannabis in a public place. Our submission is again, no, that will be against the Prince's judgment. I did indicate previously that we can probably consider religious or cultural exemption in respect of certain communities. Paragraph 7 of the comment and responses mainly deal with the offences involving a child, and that is contained in clause 6 of the bill. The first comment is that the clause is fully supported, namely the strict prohibitions against the availability of cannabis to children or giving cannabis to children or use of children to deal with cannabis. There is a remark that in paragraph 7.2 that the bill does not go far enough to deal with persons under the age of 25. It was indicated yesterday in the comments of the professors that the reality of cannabis is that it actually do affect brain development up to the age of 25 years. And I think what they indicated is that we should probably look at an increased age limit to allow legal use of cannabis. I also did point out yesterday that if you look at all the American states, there's already an age restriction of 21 years. And other jurisdictions mostly set the age of 18 years. And in South Africa, 18 years to apply to alcohol and tobacco use. So the bill follow the current situation in South Africa, namely to restrict certain conduct to persons up to the age of 18 years only. In paragraph 7.3, there is a comment to the effect that we need to clarify clause 6.1 of the bill, which provide that a guardian or a child who permits a child to possess or deal in cannabis or cannabis plants or to smoke and consume cannabis is guilty of an offense. And the question is asked, what if a parent doesn't know about the fact that his child smoke or possess cannabis? And our response thereto is that the word that is used in the context of clause 6.1 is permits. And the meaning is to allow or tolerate the conduct in subclause 6.1. Obviously, where the parent does not have knowledge of what the child does, it's my submission you cannot hold it responsible. We cannot provide for situations like that. In paragraph 7.3b, it's referred to the fact that where the adult is convicted of certain offences against the child is in risk, and social support services need to intervene to ensure the well-being of the child. This is obviously, but the bill cannot deal with this. Other legislation do provide for that, and it's mainly the Children's Act. And in paragraph 7.3c, they ask for increase of the class of offences and penalties that may be imposed, and they recommend that it must be a class C offence. It's currently a class D offence, and the class D offence is punishable with 2 years imprisonment and a fine, obviously. The class C offence is substantially higher, and it's our submission that we don't need to increase the penalty in this respect. It will not act as a deterrent, and we can actually just leave it as it is. In 7.3d, there is a referral that 6.1b may contradict clause 3.2a. To the effect that 61b allows a child under the supervision of an adult person to assist in the cultivation of cannabis plants, whilst clause 3.2a actually prohibits that. And our submission is that there's no need for that. Even in South Africa, if you look at liquor legislation, you will see that they do allow for moderate use of liquor under the control and supervision of an adult. And it deals here with mainly the cultivation of cannabis plants, and there's no real harm when adults look and oversee the activities of a child insofar as it assists in the cultivation of cannabis plants. Clause 7.4, it is proposed that there must be various additional clauses to be inserted in clause 6, and that is mainly to create an exemption. First one mainly regulates to medicinal cannabis, and it is more or less suggested that a parent or guardian can only supply or give cannabis to a child if there is a certified medical practitioner that authorizes that. And the second one further also deal with certain pre-requirements where doctor do prescribe cannabis. And our submission is the bill cannot deal with this aspect. It must be dealt with in terms of the Medicines Act. And insofar as it relates to traditional medicine, I did refer yesterday to the applicable legislation, and that Traditional Medicines Act must deal with this aspect. The bill will not deal with it. They do refer to other countries. Again, we in cultural or religious practices, we will consider that in the revision of the Act, but I cannot at this stage guarantee, as far as it relates to medicine, that it will be allowed in terms of the bill, since there's a reason why the Medicines Act is there, and the bill cannot override the Medicines Act. Paragraph 7.5 and 7.6 deals mainly with aspects that is relevant to a possible religious or cultural exemption. I'm not going to deal with this in detail, just to say that we're going to consider this at a later stage. Clause 7.7 again deals with a religious and a possible cultural exemption. And 6.5 deals with the use of cannabis as a medicine. And I did explain previously that the bill cannot deal with this. The Medicines Act and the Traditional Health Practitioners Act is the appropriate legislation to deal with this aspect. Some of the people, or rather, some of the Rastafarian comments that we did receive do indicate that there must be some kind of criminalization, even in respect of sacramental and religious use of cannabis. But I will not discuss this, and it should be dealt with when we consider a possible legal exemption on the ground of religion or culture. 7.9 from the South African Medical Association, and they do refer to the foreign position, but mostly in a medicinal context. And they do indicate, amongst others, that other countries have a concern about the recreational use of cannabis, and also the effect of children that has not yet been born, and the effects thereof on a person. I think this was to a large extent already discussed previously. And I did indicate that clauses 3, 4, 5, and 6, and especially clause 6, aims to protect children, but we can most probably not extend it to unborn children, and that such measures may probably more adequately be addressed through public education and in respect of the use of cannabis by pregnant women.
Swartja?
Honorable Swart.
Penalties, it's discussed in paragraph 8.
Mr. Robertson, can you hear me?
Page 63 of the comment.
Mr. Robertson. Mr. Robertson.
On the bill relates to clause 7.
Mr. Robertson.
To provide for clause 8.
Chair, I see Mr. Roberts has been muted. I don't. I just wanted to comment a bit on concerns about adolescence, and it's an issue which I will address as well at a later stage, but I do think we need to look very carefully at this, and particularly when reference is made to other legislation, I think we need to have a far more comprehensive look at this. I appreciate the input at this stage, but it is deeply concerning about the impact of cannabis use when adolescents. And I think this is an issue which I'd like to raise again. But I would like Mr. Robertson to particularly the offences involving a child, 6.1. I'd like at a later stage feedback on the same offence that we have in the Child Justice Act, where a person makes use of a child to commit an offence. I would like to know if there have been any prosecutions in using that act at all, because it's a very related issue. And I'm referring to the Child Justice Act provision. So, Chair, this is for later consideration. This isn't for now, but I do want to just note and flag my deep concerns about what the professors indicated right at the beginning when it comes to the usage of cannabis and the impact that it has on adolescents. And we might have to look at increasing the age or more broader consultation. Thank you, Chair.
Thank you very much. Mr. Roberts, any preliminary views? I know that Honorable Swart has indicated that he will still pursue the matter further, but any preliminary views on what he has raised?
Mr. Chairperson, regarding the possible prosecutions that were instituted in respect of a similar provision in the Child Justice Act, I will need to go back to the National Prosecuting Authority. But my submission is that it's very necessary to provide for such an offence. It actually do place at least some obligation on a parent or guardian to ensure that a child is protected. So it's part of the structure, protection mechanisms that the bill aims to implement. Regarding the possible increase of age, it may be considered. It was proposed previously in terms of the alcohol legislation. And I did yesterday indicate that some countries, mostly in America, set a minimum age of 21 years. And that's probably related to the effect on brain and under 25 use cannabis. But then on the other hand, various other countries still stick with the age of 18 years. I will discuss this further in more detail and probably when we reconsider the Act, and I will provide for certain additional options in this regard. Thank you.
Thank you very much.
Sorry, Chair.
Mr. Honorable Swart.
Can I ask Mr. Roberts also just to consult Professors Perry and Mayers on possible legal amendments in the over this period to assist with mitigating risks with cannabis? They put out very good arguments, and you have responded to them to a certain degree, but I would like a further consultation in that regard as well, as we while we have a break, just to consider mitigating risks that could result in changes. Thank you, Chair.
Thank you very much. Honorable Nivot Jurgens.
Thank you, Chairperson. Good morning to everyone. While we're still there on that part, I also want to ask, maybe later we can get research or reading in respect of pregnant women using cannabis during pregnancy, because I do know, we have the alcohol-fetal syndrome in terms of the use of alcohol during pregnancy, but I've never seen any research relating to the use of cannabis by pregnant women and what the effect is on the unborn baby. So maybe if there's some reading or research that we can get at a later stage, it would be great.
Thank you, Honorable Nivot Jurgens. Mr. Robertson.
That is noted, and first we will consult the professors. And I've got articles that's available regarding the effect on unborn children and cannabis. I will provide this to the committee timelessly before we resume with the bill. Thank you. Can I continue?
Yes, please.
Okay, I was last busy to discuss the offences, or rather the penalties relating to what may be imposed for certain contraventions of the bill. The first comment is that the penalties are unacceptable high due to the fact that it's not okay, let me rather start again. It's indicated that the penalties is unacceptable due to the fact that the perceived harms of cannabis was never proved in detail. I must indicate, yes, there is various opinions available on the internet, even some medical opinions to the effect that cannabis is not per se one of the extreme drugs. I did point out yesterday that nobody has died from an overdose of cannabis, but it is a psychoactive substance, and like any other drug, it needs to be regulated. So regarding the unfairness and extremeness of the penalties, I must point out that many foreign jurisdictions do penalize first dealing in cannabis, mostly with the same penalties that apply to other drugs in the drug legislation. There's other countries that has stepped down from this extreme standard, and certain lesser penalties are imposed for certain cannabis offences, among others dealing. I must also point out that in terms of the Drugs Act, dealing in cannabis is punishable currently with a penalty not exceeding 25 years, or a fine, or both such penalty and a fine. It must be pointed out that in the bill, a Class A offence is the most serious offence that can be committed. And the bill already reduced the penalties for dealing in cannabis, and even where you sell cannabis to a child, to 15 years of imprisonment and a fine. So we did step down from the standard that was set by the Drugs Act already. So we do treat it to a lesser extent, do treat it as an offence that is not or need not to be punished with the same imprisonment as is proposed in the Drugs Act. I must point out that although some of the penalties that may be imposed may, in the eyes of the public, be regarded as unfair, we must always remember that South African courts have wide discretion to impose penalties. And although if a person is found guilty of dealing in cannabis, let's say 10 grams of cannabis, the court will not impose a penalty of 15 years. That's obvious. The court must consider, amongst others, the quantity of cannabis involved as one of the factors that affect sentencing. My submission is that the penalties is appropriate as is provided for in the bill. In paragraph 8.2, it's pointed out that offences of penalties ensure no commercialized activities, and that is correct. And in paragraph 8.3, it is referred to the fact that only criminal punishment is considered, and which do give rise to criminal records, and other options, amongst others, decriminalization, treatment, community service, and other alternatives should be considered. I must refer currently to the Criminal Procedure Act and other legislation that deals with criminalization. They do not provide for civil penalties. However, there is reform that's ongoing in this regard. Civil penalties may be considered. Obviously, a fine is necessary in the context of a crime, which is backed up mostly by a suspended sentence. And the court may, in terms of the Criminal Procedure Act, obviously impose only a fine, not coupled with any kind of imprisonment. There's also other provisions in the Criminal Procedure Act, such as Section 255, that provide that the person may be referred for inquiry in terms of the Prevention and Treatment of Substance Abuse Act. Similar provision has been asserted in the Domestic Violence Act that was considered by the court. That may be used if a person is referred to such an inquiry, there is no criminal record. Section 276(1)(e) of the Criminal Procedure Act, amongst others, also provide that the court may, as part of punishment, refer a person for drug treatment. I did, however, yesterday indicate that one must distinguish between drug users, where I do acknowledge that we cannot use criminalization to rehabilitate drug addicts. But on the other hand, I also did indicate that the offences contemplated in clauses 3 to 6 is very necessary. Firstly, to protect children, ensure that there is no illegal markets against in dealing in cannabis, and other objectives that must be enforced in terms of the bill. Paragraph 8.4 again referred to the fact that drug abuse is complex. I'm not going to discuss this in detail. The response is mainly similar to the one I gave previously. And I must also indicate that there is a reform in the redrafting of some of the provisions of the Drug and Drug Trafficking Act that do deal with alternative measures that can be taken in respect of small quantities of drugs. We actually do deal with the person that abuses drugs. It's referred to in paragraph 8.5 by the author, again, that the penalties is unreasonable, irrational, arbitrary, and harsh, taking into account that it's a victimless offense and other criminals get lesser penalties, and also the drug master plan that do move towards rehabilitation instead of criminalization and punishment. And the same response is to a large extent applicable to this. Paragraph 8.
Mr. Robertson, just a bit. Honorable Swart. Honorable Swart, your hand is up. Honorable Nivo Trachem. I suspect those are old hands.
It's an old hand, Chair. Apologies.
Okay. Okay, you can proceed, Mr. Robertson.
Thank you, Mr. Chairperson. There is a proposal in paragraph 8.6 that we probably need to revise some of the amounts of quantities of cannabis. I did indicate previously that this may be considered. I also referred to the legislation of other countries, where there is a more stepwise increase of the quantities of cannabis or cannabis plants, and specific offences has been prescribed in that regard. I must again point out that in terms of the South African sentencing dispensation, the court must take into account the offence society and rehabilitation of the offender, and it may not be necessary due to the fact that even in terms of the Drug and Drug Trafficking Act, if you deal with something like before the Prince judgment, 15 grams of cannabis, you are guilty of dealing, but the penalty that the court can impose is not 25 years, but the court must impose a proportionate penalty. So that finishes up more or less the sentencing dispensation and penalties that is prescribed. I'm going to proceed to the expungement of criminal records. That is dealt with in paragraph 9 of the discussion, and it's dealt with in
sorry, before you proceed, on your sentencing regime, maybe one of the stakeholders that might need to be consulted is Judge Edwin Cameron. If you can also, during this break, consult with Judge Cameron. I know he's got some views on the issue of imprisonment for long sentences for people who are not guilty of violent crimes. So if we can just have a discussion with him.
Yes, Mr. Chairperson, it's noted, and we will consult with Judge Cameron.
Thank you very much.
Dealing now with expungement of criminal records, there is a proposal that we should consider a redress mechanism, which is in some instances a direct result of expungement. My submission is that if you look at the offence in question, which we try to expunge, and that is mainly possession of cannabis, the offence before the Prince judgment were in line with our international obligations, and it doesn't amount to a gross violation of human rights, but actually do give rise to a specific need for redress. I don't think we can accommodate it. In any case, the bill cannot accommodate that. It's a narrow amendment to the Drug and Drug Trafficking Act to give effect to a constitutional court judgment. There is, in paragraph 19.2, one of the major concerns here is probably the reference to a possible drafting error, as discussed in paragraph 9(2)(b), and it has been considered, and it's a technical amendment, and we will correct this. Paragraph 9(2)(c). There's a proposal that clause 8.6 must be drafted to limit the powers of the Director General to revisit decisions based on errors of fact only, and not to give the kind of open-ended discretion. It's my submission in the context of clause 8. The powers of the Director General is in any case just restricted to revisit erroneous decisions and cannot be interpreted to give him a broad discretion regarding the expungement of criminal records. Schindlers, amongst others, indicate that they do support expungement, but they also warn that some of the offences in the bill, if commercialisation did take place in the future, may need further expungement of criminal records. I did indicate yesterday that even if commercialisation is considered and implemented in South Africa, that many of the offences, if not all, that is provided in the bill will still be applicable. This is a situation in foreign countries, and it will be retained. We sought to also support the expungement of criminal records as indicated in paragraph 9.4. There is a suggestion in paragraph 9.5 that we must get rid of all criminal records regarding cannabis, irrespective of the fact that it relates to use and possession, and we must also include dealing, and that periods of imprisonment that has been imposed, such prisoners must be released, and also that all pending criminal proceedings for cannabis-related offences must be stopped. Our response thereto is, no, we cannot do that. It's fine to expunge small quantities of cannabis insofar as it relates to the use and possession of cannabis, but we cannot expunge dealing in cannabis convictions or stop current proceedings where dealing is involved. A very important aspect that is raised in paragraph 9.6 is that of the previous reverse presumption in the Drugs Act and its predecessor. And it provides that any person who has a possession of more than 115 grams of cannabis shall be deemed to have dealt with such cannabis. And there is various convictions that followed on such a presumption. It's my submission that we can consider this and allow expungement for dealing in this context only, but not dealing where the state has actually proved that a person did sell 500 kilograms of cannabis. So this will be considered in the revision of the bill. It's also acknowledged that expungement is quite a progressive step towards redressing stigmatization and marginalization in respect of drug users. This comment is noted, and I did indicate there is other reforms that is pending, which may be introduced in Parliament quite soon, that gives effect to, amongst others, our policy how to deal with drug offenders. So that concludes the discussion of expungement. I see there's a question.
About new vote reference.
Thank you, Chair. In relation to expungement, I just need to understand. So, is the process for expungement already in place? Whether or not the Prince judgment was there or not, is there already a process for expungement in place? And then secondly, the process of expungement, would it wait for the passing of the bill, or is it something that can be started before? And then thirdly, if the bill passes, or according to the Prince judgment, is it a retrospective application of expungement? Thank you, Chair.
Thank you. Any further comments or questions on this issue? None. Over to you, Mr. Robertson.
Thank you, Mr. Chairperson. Currently, Section 271B of the Criminal Procedure Act do provide for the expungements of certain criminal records of a person. Some of the offences included under that provision is, amongst others, where imprisonment and an alternative of a fine has been imposed, or just a fine has been imposed, or certain other sentences of a non-penal nature were imposed. That is in place currently in respect of all non-serious offences. We further prescribe how it must be done, etc. So there is a current expungement mechanism in place. Regarding the provisions of the bill, this expungement mechanism will only take effect once the bill is passed by Parliament and implemented. It's something that is provided for in addition to what is currently in the Criminal Procedure Act. The reason therefore is, amongst others, that you cannot let a person wait 10 years to get a criminal record expunged on a recent conviction of use and possession of cannabis. The retrospective effect, yes, this will apply to previous convictions retrospectively. It actually, any person who has a previous conviction, when the bill comes into operation, that previous conviction will be regarded as being expunged. So it has a retrospective effect. I hope I clarified that.
Proceed. Proceed.
Thank you, Mr. Chairperson. Clause 9 of the bill deals with regulations, and there's a comment that the regulations should be quite broader, and amongst others deals with aspects regarding hemp, chemicals used in the cultivation of cannabis at home, also prescribe THC that is found in edibles, and it must also promote research and development and provide for awareness raising and education regarding cannabis plants. Again, I must point out, and as discussed yesterday, the bill has got a very limited aim. Other departments mainly deal with other aspects, some of which is proposed here. Hemp must be dealt with in terms of other legislation. Regarding the chemicals used in cultivation of cannabis, I don't think that is actually really needed. In foreign jurisdictions, the chemical aspect of concern that is addressed here mainly relates to chemicals that is used to extract THC and make other edibles, or to make or to extract THC. Again, research and development awareness raising must be promoted by other departments. Awareness raising regarding the harms of cannabis is addressed in the legislation that deals with treatment and rehabilitation of drug offenders. It's got wide provisions, involve all departments, and it may be used for this specific purposes. The second last part deals with the repeal and amendment of certain laws. And the first aspect that is dealt with here relates to amendments to the National Road Traffic Act. In terms of the National Road Traffic Act, there's also certain provisions that has been amended, amongst others, to provide for the driving under the influence of THC. And the specific limitation is prescribed in amendments to the National Road Traffic Act, mainly Section 65, which deals with driving or occupying a driver's seat of a motor vehicle while the person is under the influence of alcohol or drug, and specifically in terms of the amendment, also THC. And the first question is, it is unclear how the limit of THC in the bloodstream has been established to determine intoxication. I do provide quite a scientific explanation. I won't go through it in detail, but the effect is that we looked at foreign legislation, how other countries deal with cannabis use and driving. The first is Canada, and in terms of the Canadian legislation, it's the blood concentration regulations that were enacted to deal with, amongst others, driving under the influence of THC. There's certain blood limitations that is prescribed, and that is nanograms per milliliter. It provides for summary conviction if if the THC in your blood exceeds 2 nanograms per milliliter, that is less than 5 nanograms. And if it's only over 5 nanograms, it's a standalone offense and a person can be convicted for driving under the influence. It also makes provision for combinations offenses. That is where a person used THC in conjunction with alcohol and other drugs. And this combination offense set the limit at 2.5 nanograms per milliliter THC if it's combined with alcohol or other drug. In the United States, it's dealt with differently. Various states did set a 5 nanogram threshold for THC. Some of the states indicated on page 70 to 71, amongst others, Colorado, Montana, and Washington. There's some states that provide for a limitation of 2 nanograms per milliliter, and Pennsylvania provides for 1 nanogram per milliliter. Certain states provide for any drug or metabolite in a person's bloodstream, any detectable amount. Some states however, do require that there must be impaired driving. In terms of the current provision of the National Road Traffic Act, it also provides that a person will be guilty of an offence if he drives or is behind a motor vehicle while he's under the influence of a narcotic substance. It's probably better to explain this in more detail to everybody. If you look at cannabis use and consumption, there's some technical documents and there is research that has been done and it's available on the internet. It refers to the fact that if a person smokes cannabis, the THC concentration in his blood will, during the use of cannabis, rise extremely high. Some instances, it was detected at above 100 nanograms per milliliter directly when a person smokes that. But then there's a period where it slopes downwards. And a person that uses cannabis, if he is in most instances above 5 nanograms per milliliter, can be regarded as to be under the influence of THC, since he cannot, or rather, let me say, it influences his judgment as well as control over the driving of a motor vehicle. Also, the other aspect is if you eat cannabis, the THC in your bloodstream directly after the use will not rise significantly. It takes a period of time to be absorbed in your blood, and it then, if it's absorbed, there's some authority to the effect that levels of 5 nanogram or above of THC in a person's blood is detected. I must indicate that the person that smokes cannabis, the effects starts quite quickly within a few minutes, and the smoking effect of cannabis lasts between 1 to 4 hours. If you consume cannabis, the effect on your body can last up to 8 hours long. And in the foreign, or the research that was done, do indicate that insofar as it relates to THC in the blood, if a person is above 5 nanograms, he will be under the influence and cannot control his actions adequately. And the question is also asked then, how will a person be tested at a roadblock? And I did respond, among others, to the position in Canada where oral flu drug screeners is used, but it's also necessary to indicate that there's various other mechanisms that is used to determine whether a person drives under the influence of alcohol or drug. That's amongst others, that a person has red eyes, muscle tremors, slurred speech, and impairment of body control. So that is indicators that do supply some information that a person may have consumed drugs. But yes, if we move to the criminalization of driving under the influence of THC, additional training and probably additional equipment needs to be provided to the law enforcement agencies. In paragraph 1, 11(1)(c). There's reference made to some foreign jurisdictions that specify a zero legal limit. I did indicate that this may be considered, but on the other hand, one must take into account that a person that's under 5 nanograms per milliliter is in most instances not under the influence and can adequately, to an extent, control his actions. The use of cannabis in medicine is probably going to skyrocket, and some people may use medicine containing THC, and if there's a 0% limit, such a person will fall within the web of the amendments to the National Road Traffic Act. In paragraph 11.2, reference is made to the fact that yes, cannabis do affect the functioning and judgment of a person, and it may lead to motor vehicle accidents. And it's also pointed out that there's a need for equipment and additional training to deal with this aspect. If South Africa is going to consider commercialization of cannabis, obviously the use of cannabis will substantially increase. It needs to be strictly controlled and enforced. And yes, there must be available funds for training and equipment to deal with driving under the influence of THC. In paragraph 11.3, it's referred to the fact that the proposed amendments have no scientific basis. I did refer to other countries which do provide for a similar limitation as those proposed in the amendments to the National Road Traffic Act. And I believe they did consider experts in that regard. I did try to discuss very shortly the effect of cannabis and what some experts remarked relating to blood THC content and driving under the influence of THC. I'm not going to go through this longer discussion and what to do with 11.4. And reference is then made to the fact that the National Road Traffic Act did try to promote a zero blood alcohol limit. I don't think that has been passed or further promoted. But in addition to that, an aspect that is quite relevant in the context of the amendments to the National Road Traffic Act is mainly where a person uses cannabis in conjunction with alcohol. It has, if both drugs, or let's call alcohol and THC, is used together, it really seriously impaired a person's function. And there is legal limits in the amendments to the National Road Traffic Act to cater for drugs used in conjunction with, amongst others, alcohol and also other drugs. But other drugs need to be prescribed. And it's my submission that the provisions or the amendments to the National Road Traffic Act is in line with that of foreign legislation. In paragraph 11.6, objection is raised to the fact that breathalyzer tests for cannabis is not required to date. And I must point out, the bill does not provide for breathalyzer tests in respect of cannabis, but it's usually where there is other alcohol involved. The breathalyzer test in section 6511 deals with the testing of alcohol. THC must be detected and through other measures, and laboratory testing is required to determine the precise amount in a person's blood. So that ends the comments and the department's responses thereto. Thank you, Mr. Chairperson.
Thank you very much, Mr. Robertson. Any comments, members? Dr. Niveau Strachans?
Thank you, Chairperson. If you don't mind, I have 3 questions with regard to something that was discussed yesterday. Is it okay if I have 3 questions?
Proceed.
Thank you very much. Mr. Roberts, I just wanted to understand where and why did it come up in terms of the measurements? Yesterday you spoke about, there was something about the plant size, 15 centimeters high and 15 centimeters wide. Now, that's half a ruler size, right? So it's quite small. I've never seen a cannabis plant, so I don't know. But from pictures that were shown during public hearings, they can be quite big. Now, I'm just trying to understand where in the bill comes with the measurement of 15 centimeters by 15 centimeters, or is it just for private use at home, and that is why it is such a size like that? How do you keep a plant that size? Then I'm also trying to understand if the bill, if I can't grow it at home, I have no space, but maybe another person, or I get it from another person. It's for private use, yes, but now I'm traveling with it while I go to and fetch it from the person who is giving it to me. It's for private use, but now there's roadblock and they find me with cannabis in my possession. Now, because I can't grow it at home for private use, I need to go pick it up somewhere, but now I'm traveling with it, and that is a problem. Now, the strength of the THC, I see in South Africa, we have to keep it at 0.2 in terms of the strength. But during the public hearings, they were saying that the climate in South Africa is not, with the sun and the weather changes, it's impossible to keep it at 0.2. So how and why do we compare it to foreign areas where the climate is different? And why do we keep it at 0.2? So that's my questions. Thank you, Chair.
Thank you. Is that all, Honorable Niveau Strachans?
Yes, Chair. That's all.
Thank you very much, Honorable Swart.
No, thank you, Chair. And I really appreciate the department's very lengthy response, Mr. Roberts' very lengthy response. However, as indicated previously, we have very serious concerns about the possible abuse and the possible unintended consequences of widespread recreational usage of cannabis. We understand the religious side of the issue, and we will definitely consider the religious exemption that will be looked into. But I just want to add to what I indicated earlier, and the concern that we've previously expressed about adolescents, the impact on adolescents, and we appreciate the fact that you will consult with the 2 professors. But I would, Chair, I understand this is a very narrow bill, but it has very broad implications for other departments and other legislation. We already had those inputs from other departments. So I would like Mr. Robertson to, over this period, and obviously, Chair, the committee needs to discuss this, but I don't think it's sufficient. And whilst I appreciate from a legal perspective, Mr. Robertson is correct, but just to say the Substance Abuse Act will deal with the possible broader implications of substance abuse. We've already got submissions before us indicating the broad aspect of substance abuse and the impact on the health committee, the impact on the health department, that they are already severely constrained. And so when we pass in legislation, it must be in the common good. We can't pass legislation that could result in greater harm to society. And so particularly when it comes to the adverse impact of the abuse of cannabis. So Chair, I want us to, when we, and maybe Mr. Robertson can think about this, to consult with other departments. I think, as we've done in the past, should it be necessary for us to consider amending other pieces of legislation, we might have to do that as well. But we are sitting with a very narrow bill here in terms of a constitutional court ruling that has, yes, I understand the impact or the privacy argument, but it has a very broad impact on society in general. And as my colleague, Honorable Niva pointed out, it's not good enough to just say the alcohol legislation provides for this. We already know alcohol fetal distress. So we need to have a broader understanding of the impact of this regulation. Yes, it's regulating, but the broader impact on society to ensure that we are exercising our mandate as Parliament, which is to improve the quality of life of South Africans. We need to legislate for the common good within the constraints of the Constitutional Court ruling. I don't think at this stage that we sufficiently have enough information about the broader impacts and that we are approaching it very narrowly. And I think we need to consider the social impact, the other impacts that is covered by other pieces of legislation, but they are already severely under-resourced. How are we going to deal with that, Chair? And I think that is going to be part of our broader deliberations early next year. But I would like Mr. Robertson to consider, Chair, subject to your ruling, of course, how to consult with those other departments and other entities that are impacted by other pieces of legislation. I also join Ms. Niva concerns about the 0.2% when it comes to hemp, which is very low THC, and we know in South Africa that our conditions do not necessarily support that. We already see that the agricultural department has issued permits where it is making mention of 0.2% in terms of the Plant Act. So there are a number of pieces of legislation that impact on this. So when we consider this again, I think whilst we appreciate Mr. Robertson's work, it's very narrow, and we would need to broadly consider all these aspects as the legislators. The department comes and gives us their impact and their input, and we appreciate that. But at the end of the day, we as parliamentarians have to legislate for the common good and not necessarily legislate for the common harm of society. So we need to be very mindful of unintended consequences. Thank you, Chairperson.
Thank you very much, Mr. Robertson.
Thank you, Mr. Chairperson. First, let's deal with the 0.2% THC. The 0.2% THC firstly relates to hemp. And the Honourable Swart is correct. I think the current regulatory measures that's used to cultivate hemp do prescribe 0.2%. In terms of the bill, if one look at the definition of hemp in clause 1.1, the bill itself does not specify a minimum concentration of THC. It actually leaves the hand of others and other legislation to determine that amount. I did indicate yesterday with reference to most other countries who have hemp legislation in place that not all countries found themselves bound by the 0.2% or 0.3% THC content for industrial hemp. Some countries even go as far as prescribe up to a 1% THC content. Regarding the remark of THC of 0.2%, that must also be considered then in relation to cannabis edibles and the concern I did discuss yesterday, where currently the definition of cannabis plant just make reference to any product that contains THC. And I did indicate that we probably need to amend that part of the definition to at least specify a minimum amount of THC in such products. And I did refer amendments to the Medicines Act in Schedule 6, where it excludes from the schedule of the Medicines Act products that contain less than 0.2%. So obviously, it's my submission, if we want to amend the edibles or products containing THC, insofar as it relates to the definition of cannabis, that we can use that limit as prescribed in Schedule 6 of the Medicines Act. I must indicate, ordinary cannabis that is used for recreational purposes usually contains something like between 5% to 20% THC that is available for consumption or recreational use. And that is the strength of the drug in cannabis that cause the effect. We do not intend to regulate that, but that's regulated in terms of the law, amongst others, mainly through measures that limit the amount of cannabis you may possess. But I must admit, yes, there is a probability that some people may possess more potent cannabis and others less potent cannabis. But I can find no authority in any other country that specifically deals with this aspect. It's merely the amount of cannabis you possess, and that is the limit of a regulation. Regarding the sizes to which I referred to yesterday, in terms of the bill, the various definitions, and I must refer firstly to that of a seedling, which is regarded as cannabis cultivation material. Seedling is prescribed as a cannabis plant smaller than 15 centimeters. If it exceeds 15 centimeters, but it's not flowering, it is regarded as an immature cannabis plant. And if it's flowering, it is regarded as a mature cannabis plant. And that also is very relevant to the various provisions in the bill. In clause 2.3, adult people may exchange, amongst others, cannabis plant cultivation material amongst each other. And they also may exchange a prescribed quantity of cannabis plants. And In relation to the free exchange of cannabis plant cultivation material, there's no limit on the exchange of seedlings. So if the seedling under 15 centimeter may be exchanged, no problem. There's however a limit on cannabis plants that may be exchanged. And cannabis plant, if it's over 15 centimeter, not flowering, there's a certain limitation on that. And there's also a limitation on the exchange of flowering cannabis plants. It also relates to your cultivation offences, where that distinction is necessary, due to the fact that it also limits the fact and penalizes a contravention where you, amongst others, distribute seedlings or cannabis cultivation material, an immature cannabis plant, and obviously a mature cannabis plant. So that is the reason why there is a size limitation. I did indicate previously that we can probably get remove the reference to this 15 centimeter width and height in relation to immature cannabis plant. But if we do that also in relation to a seedling, it will kind of blend everything together, and there will be no distinction in that regard. I hope I answered everything. And with regard to what was said in the committee amongst others by the Honourable Mr. Swart, we will, during this period, amongst others, consult with the professors. There was consultation with other departments, but I think the concern that was raised is, do we not overburden obligations in terms of other legislation that's imposed on other departments to deal with the harms associated with cannabis? That may be so, but that will, if we consult with that, it will specifically be discussed. But it must also be pointed out that the Department of Justice hasn't got, firstly, the people to deal with harm reduction measures in respect of legislation relating to drugs and drug abuse. It is also always other department that must deal with that. We are responsible for administration of the Drug and Drug Trafficking Act. And our main role is criminalization and enforcement thereof through the courts. Or if we impose obligations, other departments must, within their mandate, take that effects that may result from such legislation within their mandate and introduce appropriate measures. But it will be discussed with other departments and also other entities. Thank you.
Thank you very much to Mr. Roberts.
Okay, meneer Drucken. Just with regard to the road, the transporting of the, there was no response on that.
Sorry, Mr. Chairperson, if I may respond now. If one exchanges cannabis between adults, obviously you can provide it to other person. There is, however, restrictions on that in terms of cultivation material that may be transported. It, amongst others, provide that if you transport cultivation material, there must be compliance with certain aspects prescribed in the Act. It deals, amongst others, or rather criminalize obvious trafficable quantities and the quantities that may be exceeded. If you're in possession of cannabis plant cultivation material which may be exchanged without remuneration as contemplated in clause 2.3. It's my submission that you can transport it. It's not criminalized in the bill, so you can take it from one place to another place and give it to another adult person. In that narrow context, I hope I address the moving for exchange of cannabis and cannabis plant material. One can also consider clause 4, which do provide, amongst others, for the transport of cannabis in a vehicle. I think it's dealt with more or less in clause, the latter parts, clause 4.6. There must be certain standards that must be complied with if you transport raw cannabis. In most other countries, it requires that if you do transport cannabis, it must be in a sealed container in your boot of your car, or sealed in a bag if you take it from one place to another. So it is possible, and the bill do accommodate for the transport of cannabis from one place to another for the ambit as proposed by clause 3.2, namely exchange between adults. Thank you.
Thank you very much. I hope Honorable Nevot are now answered.
I am. Thank you very much, Chairperson.
Thank you very much, Honorable Swart.
Thank you, Chair.
Oh, okay. As we said yesterday, we are encouraging the department to interact with all the relevant stakeholders, including the Rastafarian community, in now drafting the legislation. We have also identified other stakeholders, but they're not limited to those stakeholders. Professors that were mentioned today, Judge Alvin Cameron, and you can identify other stakeholders. We will be able, or we will be in a position to really deal with this bill after the State of the Nation. So that would be around late February, March, that we might start concluding the bill. So we are giving you this time, January, February, or even early March, to do the consultations and a drafting of a bill that can be considered by the Portfolio Committee. Thank you very much, Mr. Robertson, and to your team.
Thank you, Mr. Chairperson. The extended time period is appreciated. At least it's not 48 hours. No, we will do it. Thank you.
Yes, no, we've given you enough time so that you can also consult with the stakeholders, because one of the issues that we flagged yesterday was the issue of exemptions for religious purposes, which we thought that it would be important that you engage with the Rastafarian communities around it, but there are also other issues, and we have identified certain stakeholders, but they're not limited to those stakeholders. You will look at the bill in totality and identify stakeholders that would want to further engage.
We'll do that. Thank you, Mr. Chairperson.
Thank you very much. Can we have yes, others are talking about traditional leaders, but we are giving you a scope to look at all of those stakeholders. Can we have a 15 minutes break? And then we will start with the BRRR for correctional services thereafter, which means we will come back at 11:15.
Thank you, Chair.
Thank you. Correctional Services. Budgetary review and recommendation report of the Portfolio Committee on Justice and Correctional Services, dated 24 November 2021, draft report. Are there any corrections on page 1? I think this report was circulated and is taken as read. Are there any corrections on page 1? Can you scroll down? Down. Page 2. Scroll down. Down. Page 3. Scroll down. Scroll down. Scroll down. Page 4. Honorable Nola, is your hand up?
Chair.
Honorable Nola? Honorable Nola?
Can you hear me now, Chair?
Yes, we can.
Okay, can you go back to the diagram or the graph of the audit outcomes?
Yes.
Yes, on the 2020-2021, on the part of the areas of qualification, remember unqualified, you may have unqualified without any findings, or you may have unqualified with findings. Should you not write that there in that part?
Is that is an unqualified with matters of emphasis? Is that not correct?
Yes, it is, Chair. I think there were two issues. It's underspending and
Wasteful expenditure.
yes.
That was not investigated. Yes. So can we correct it accordingly?
Yes, we'll include it, Chair.
Thank you very much, Mr. Matawati. Thank you very much, Honorable Nola. I can see today that there's a big tree and children.
It's Werner Horn speaking.
Honorable Horn?
Yeah, if we are to do that, then I think we must just change the heading there, Chair, because it talks to areas of qualification, which is then technically not correct because it isn't unqualified audit, it's just matters of emphasis. Thank you.
So what would you suggest we write, Honorable?
Well, maybe areas of qualification dash, what did we say? Matters of emphasis, yeah.
Matters of emphasis, okay.
Yeah. Thank you.
Thank you very much, Honorable Horn. So can you go down? Page 4. Go down. Page 4. Page 5. Go down. Page 5. Page 6. Please go down. Go down. Page 6. Page 7. Go down. Go down. Page 7. Page 8. Go down. Go down. Page 8. Page 9. Go down. Scroll down. Page 9. Page 10. Scroll down.
Chair, Honorable
Just ahead.
Okay. Honorable Neville Strachans.
Thank you, Chair. Page 9, at the end, 8.2.4, in brackets, at the end of the line, it says searching. Why is that there?
Yes.
Searching, the word searching in brackets.
Thank you very much, Mr. Matabate.
Chair, the department, when they reported that some of the contributory factors to the escapes were that officials did not comply with security policies and procedures. So specifically, searching of offenders in correctional facilities. So that's what they've put as well. So hence I've put it that it was about not searching offenders.
Now, Mr. Matabate, somebody who will read this document 10 years from now, how would he make sense of this searching in brackets?
I think we can fix that, Chairperson. Sorry about that.
Honorable Nebo Trachans, are you satisfied?
Yes, and it is true that you say 10 years later, they're not going to understand what this means. So yes, just to fix that so that it makes sense. I agree with that. Thank you, Chair.
Thank you very much. Page 10. Can you scroll down? Scroll down. Scroll down. Thank you. Page 10, page 11. Scroll down. Page 11, page 12, page 13, scroll down, page 13, page 14, page 14, scroll down, page 14, page 15, scroll down, page 15, page 16, scroll down, scroll down, page 16, page 17, scroll down, page 17, scroll down, page 18, scroll down, scroll down, page 18, page 19, scroll down, 19, 20, 20, scroll down, scroll down, 20, 21, scroll down. Mm-hmm. 21, 22. Scroll down. 22, 23. Smell is better. 22, 23. 23, 24. 24, 25. 25. Scroll down. 5, 26. 'Can I have a mover for the adoption of the report as corrected?
Chair, Honourable Woman Yuho Druchen moves for adoption.
Honorable Nugo Druchen moves. Any seconder?
Chairperson,
Honorable
second.
Masako Jele seconds. Any objections?
It's Werner Ron speaking. It's no objection, just the reservation of our position.
Reservation of the Democratic Alliance. The report is adopted with corrections. Can we flight the next one?
So the DA is on standby.
Janky, you know what on standby mean in the Western Cape.
Can we focus on the work at hand, members? The budgetary review and recommendation report of the Portfolio Committee on Justice and Correctional Services, dated 24 November 2021. The Portfolio Committee on Justice and Correctional Services, having considered the financial and non-financial performance information of the Office of the Chief Justice and Judicial Administration for the financial year ending 31 March 2020 and first and second quarter of 2021-2022, report as follows. The report will be taken as read. The report was circulated on time. Any corrections on page 1? On page 2. On page 3. On page 4. On page 5. On page 6. On page 7. On page 8. On page 9. On page 10. On page 11. On page 12. On page 13. On page 14. On page 15. Can I have a mover for the adoption of the report?
Honorable Newhood Griffin moves for adoption, Chair.
Honorable Newhood Griffin moves. Any seconder?
Chair, I second.
Honorable Museko Jelo seconds. Any objection?
Just to not disappoint the Honorable Janki, I reserve the position of the DA.
The DA reserves its position. The report is adopted. Can we now go to the minutes? Draft minutes of the Portfolio Committee on Justice and Correctional Services dated 7 September 2021 on the virtual platform. Any corrections on page 1? On page 2? On page 3? On page 4? Is there a mover for the adoption of the minutes?
Chair, I move for the adoption of the minutes.
Honorable Maseko Jalo moves. Any seconder?
Honorable Nieuw-Drugen, seconds.
Honorable Nieuw-Drugen, seconds. Let's first check, let's go to the minutes, whether the people who moved and seconded were part of the meeting. Can you go back to the minutes? Yes, they were. Thank you very much. Can you go to the, were there any objections to the adoption of the minutes?
No, Chair.
No objection. Thank you very much. The DA is not reserving its position in the minutes.
I'm watching them. I'm just watching.
In our view, the ever-present long speeches of the Honorable Jantjie is not properly reflected in the minutes, but we'll keep silent about that for now.
Oh my God.
Let's go to the second set of minutes. Draft minutes of the Portfolio Committee on Justice and Correctional Services, 8 September 2021 on the visual platform. Any corrections on page 1? On page 2? On page 3? On page 4? Is there a mover for the adoption of the minutes?
I move, Chair.
Honorable Ngola moves. Any seconder?
Honorable
Second.
Nieuw-Drugen, seconds.
Honorable Nieuw-Drugen, seconds. Any objections? No objections. The minutes are adopted. Minutes of the Portfolio Committee on Justice and Correctional Services, date 9 September 2021, on a virtual platform. Any corrections on page 1? On page 2? On page 3? Page 3? You scroll down. Page 3. Any mover for the adoption of the minutes?
I move for the adoption
Really,
of
I
the
move
minutes, Chair.
for the adoption. Okay.
So who's moving?
Okay,
Honorable Nieuw-Drugen, Honorable Chairperson, Honorable Nieuw-Drugen.
Honorable Nieuw-Drugen moves. And then any seconder?
I second, Chair.
Honorable Masego Jele seconds. Any objections? No objections. The minutes are are agreed to. So the other set of minutes. Draft minutes of the Portfolio Committee on Justice and Correctional Services, date 9 November 2021, virtual platform, Zoom. Any corrections on page 1? Just let's go to page 1. Let's go up. So yeah, on the apologies, it's reflected here that Honorable Iago apologized. My understanding is that she now serves on the Portfolio Committee of Trade and Industry. Did she forward an apology?
No, Chair. Chair, our understanding is that she says a standing apology because she's serving in her main committee. So until there's an interest, she will attend this side.
Okay. No, that's fine. Okay, page 2. Page 3. Page 4. Page 5.
Chairperson, Honorable Mayor Druchen, page 4.
Page 4. Let's go to page 4. Honorable Niveau Druchen.
Page 4.4.
Yes, Honorable.
Okay, so at point 4, the second bullet, can you separate
Yes.
the word?
Yes. TCS.
Yeah, TCS, yeah.
No, that one is done. Thank you very much, Honorable Niveau Druchen. Page 4.5. Page 6. Any mover for the adoption of the minutes?
Honorable Mayor Druchen moves for the adoption of the minutes, Chair.
Honorable Niveau Druchen moves. Any seconder?
I'll second, Chair.
Honorable Horn seconds. Any objections? The minutes are adopted. This other set of minutes, draft minutes of the Portfolio Committee on Justice and Correctional Services, 10th November 2021 on the virtual platform Zoom. Any corrections on page 1? Page 2? Page 3? Page 3? Page 4. It's page 3. Any mover for the adoption of the minutes?
Honorable Mayor Drucken moves for the adoption, Chair.
Honorable Nibo Trahans moves. Any seconder?
Second, Chair. Honorable Mola wants to.
Honorable Mola seconds. But it would be better, Honorable Mola, to have.
I think, Chair,
Honorable Horns seconds.
yeah, I think let's keep it.
Yeah, Honorable Horns seconds. The minutes. Any objections? Honorable Mola maybe want to object.
No, Chair, I object any objection that may come now. The objections are objected.
Okay, no, maybe you would want to object that the tree on that day was not there. The minutes are agreed to. The next set of minutes, 12th November, minutes of the Portfolio Committee on Justice and Correctional Services, 12th November 2021. On a virtual platform, Zoom. Any corrections on page 1? Page 1, page 2. Page 2, page 3. Any mover for the adoption of the minutes?
Honorable Mayor Drucken moves for the adoption, Chair.
Honorable Nibo Trahans moves for the adoption of the minutes. Any seconder?
Seconded, Chair.
Honorable Mola seconds. Any objections? No objections. The minutes are agreed to. Do we have another set of minutes? Minutes of the Portfolio Committee on Justice and Correctional Services, date 17th November 2021, on a Zoom virtual platform. These were the interviews. Any corrections on page 1? Page 2? Page 3?
Okay.
Page 4?
Chairperson, Honorable Mayor Drucken, page 3.
Page 3.
Yes, 3.2. Mr. Gwala is supposed to be with an M. It's Mr. M. Gwala, not F. Gwala.
Yes, Mfana, yes. Thank you very much. Page 2, page 3. Page 3. Is there a mover for the adoption of the minutes? Honorable Nico Druckens.
Honorable Mayor Drucken moves for the adoption, Chair.
Honorable Nebo Dragans moves. Any seconder?
Second, Chair.
Honorable Werner Horn seconds. Any objections? No objections. Minutes are agreed to. Draft minutes of the Portfolio Committee on Justice and Correctional Services, 18 November 2021. Consideration and adoption of the draft reports on the filling of vacancies at the Information Regulator. Any corrections on page 1? On page 2? No. Is there a move for the adoption of the minutes?
Chair, I move for the adoption.
Honorable Secretary moves. Any seconder?
Honorable Mayor Drucken seconds the adoption, Chair.
Honorable Nebo Drucken seconds. Any objections? No objections. The minutes are agreed to. Minutes of the Portfolio Committee on Justice and Correctional Services, 19 November. Briefing by the Special Investigative Unit, Legal Aid South Africa, and Information Regulator on 2020-2021 Annual Report and Quarterly Performance Reports 2021-2022. Any corrections on page 1? Page 2. Page 3. Page 3. Page 4.
Chair, my apologies.
Honorable Horn.
There at the ICU, if we can just go back there, I think at the beginning, the ICU is called a department, which technically is not correct, of course.
Okay. Under 2.1.
Yes, yes, thank you.
Thank you very much. So we're on page 3, page 4. Any mover for the adoption of the minutes as corrected?
I move, Chair.
Honorable Horn moves. Any seconder?
A second, Chair.
Honorable Jailer seconds. Any objections?
Record, Chair, with the emphasis that it's not ICU, it's Mr. Horn.
Why is that?
Mr. Horn was saying ICU, Chair. I was trying to check.
Okay. So the minutes are adopted with corrections. Great too. Thank you very much. Is that the last set of minutes?
Yes, Chair. We only have minutes from yesterday and today are standing.
Can we be in a position to adopt those minutes on Friday?
You can do that, Chair.
Thank you very much. That brings us to the end of our meeting for today. Members, I'm informed that on the day of the 10th, we will have a sitting in the morning. Now I'm proposing that the committee secretariat organize transport, a bus that will immediately take us from Parliament to Mr. Self's house on the 10th. And then they organize transport for various members who would be going to their respective villages or homes, except those members who would have organized their own transport. But it would be good to have one transport, even if you have a car, just so that we can be able to bond also. It has been long since we last met physically, just to bond as we would be going to Mr. Self's house. Is that in order?
Chair,
Mamujele?
are you sure you want to bring Honorable Breitenbach and Comrade Janji on the same transport?
I think if anything happens, we have you and Honorable Swart who will just pray for them.
Mr. Chair, may I speak?
Yes, Honorable Breitenbach.
So, the Honourable Maseko Jele the only thing she could do would be to pray, because for the rest she's, too small. And Honourable Janki can sit next to me, it's fine. If there's any difficulty arranging transport, Mr. Chair, I can arrange a quantum bus or a small minibus with the Honourable Bagram to take everybody. So if that's a second option, if it's difficult to arrange transport. Yes, and then, Mr. Chair, may I just say that we're extremely grateful, really. I cannot express how grateful we are that the committee is prepared to do this thing. And Mr. Self will appreciate it so very much. Thank you.
Well, Mr. Self is one of us.
Definitely. We're team justice. We're team justice.
Yes,
so we work.
We are one family. We are one family. We, in good and in bad times, we are one family. So we really want to visit him. And we're even suggesting that the team that will be coming to Gauteng for the oversight, if we can also visit the home of Mam Fukeng, because members might not be aware that within a month or so after her departure, her mother also died. And so when we are this side, then we can also go and just pay her a visit.
That would be wonderful. Thank you, Mr. Chair.
Yes, because you will soon realize, members, that we spend most of our time at work. So work becomes an extension of our family. So when I see you, I see my brothers and sisters, and I think that the same applies to you. So we have to ensure that we really enjoy, we work hard and play hard, but we must always be there for each other. So let's try, members, but one of the things that I would also like to bring to the attention of the members is that our program is going to change a bit. We are working with the chair of the subcommittee. From next week, we will have 1 week for the committee, and then 1 week for the subcommittee. Secondly, it would be important also, especially the researchers and the committee secretariat, that before we adjourn, we have a meeting where we would you would have already drafted a draft program for the oversight, so that those key areas and areas to be visited, the thematic areas that will be guiding our oversight visit can be discussed and be agreed to by all members, because we want an oversight visit that is going to be a committee oversight visit, where every member would feel that he or she has made a contribution. His or her area of interest is broadly covered, because we might have 1 or 2 of such oversight visits. Justice does not get to do oversight visits. So it will be an intense visit, oversight visit, and we would like to ensure that we agree on the program as the parties, so that because the likelihood is that we will split into 2 groups, but we must know that even the group that will be going to the other side of the country, we're doing the same thing, more or less. We're covering the same issues, so that we will be able to draft 1 report to the House. Is that in order, members?
Yes, Honourable Chair.
Thank you very much. The meeting is adjourned.
Thank you, Chair.
Thank you.
Thank you, Chair. Bye, everyone.